South Africa has accused the International Criminal Court of double standards. In an exclusive interview with SABC News, International Relations Minister Maite Nkoana-Mashabane accused the ICC of lacking the will to prosecute permanent members of the United Nations Security Council. SABC reporter Aldrin St. spoke to the minister and began by asking her if the decision to withdraw from the ICC was difficult to make.
I think Minister Masuta is a Minister of Justice, so he takes care of our his responsibility in keeping us safe in terms of our constitution here at home. But I do know that ever since we signed and ratified the Rome Statutes, we always understood that to be the last port of call, that national institutions of justice have to be strong or capacitated. Secondly, there will be regional mechanisms. And that thirdly, then we'll have the ICC. So since the inception of the ICC during Madiba's time, I reconfirmed this with my predecessor, who was the current chair of the AU Commission, just this part, that whether she had had a similar experience that I had, that out of now more than 123 countries who are members of the Rome Statutes, in between or annually we're supposed to attend a gathering called Assembly of State Parties, wherein we will review, relook, strengthen the articles of the Rome Statutes. Lo and behold, you get to the meeting, majority of the attendees are NGOs. State parties are representatives of government expectation at ministerial level. The last Assembly of State Parties I attended last year, there were only 9 ministers in the room.
Wow.
2 from South Africa, 3 from Kenya, 1 from Palestine, the rest from Latin America. There was not a single member of the state parties from the whole of the Western world. That's one. Number 2, I think as South Africans, because I think I wouldn't say we're insular, but we are too maybe busy at home. We've even forgotten that when at the inception of the Rome Statutes, even the USA signed on through President Clinton and unsigned during President Bush, and they've never shown any intention of coming back. I had our usual biennial dialogue with Secretary Kerry about a year ago. He once again repeated that they had no intentions of going back to the ICC. As I'm sitting here with you, let's start here first. The South African Constitution, in particular Article 231, bracketed 2, gives us mandate delegated to us. I'm talking about international relations. The responsibility of taking care of South Africa's national interests outside the country. So therefore, we sign international treaties, and we have also chosen as a government and as parliament, as South Africans, that we would take this for ratification, any other international instrument, to parliament for ratification. So it means even if we then have an intention to unsign or to withdraw, we will give an intention to do so to the requisite institution. In this case here, the UN Secretary General's office. I'm taking a bit of your time to say, by the way, the UN as the UN is not a member. It should be the other way around. The supreme body of international law is supposed to be the UN. So we have no qualms in writing to the Office of the Secretary General. But you know that the most powerful body, the UN and institutions of governance, is the UN Security Council.
Yeah.
Out of the 5 members of the Security Council, only 2 are members of the ICC. The US is not a member, China is not, Russia is not. So, further giving you examples, there were allegations of some atrocities committed by the US soldiers in Afghanistan. But we have seen no intention whatsoever by the ICC to pursue those cases. We know of cases that have been lodged recently by the Palestinians, the newest member, against Israel. No movement. We are also aware of cases lodged by Iraqis against British soldiers during the then Iraq war. No intention whatsoever. So this is what gives the Africans this feeling that there's no movement forward. So I don't want us to think South Africa woke up and said because there was this case about Bashir, so we are reacting. Ours was not a reactive decision. We followed the law to the letter, as also confirmed by part of the judgment that the Supreme Court gave, that we in this room met as the security cluster 25 days before the hosting of the AU summit, because when you host an international meeting, you give certain precedent in your own country, you hand over to the institution that will be conducting the meeting. In this instance, if it's UN, like I chaired the COP17 of the UNF Framework for Climate Change in 2011, we handed over certain parameters to the UN. In fact, even when you arrive there, you'll find South African police on the outer periphery, but in the inner periphery you'll find UN soldiers. UN police. Same as in when we were to host the AU summit. Everywhere else, you will have protocol and other responsibilities. 25 days before the hosting, you make a public gazette and you hand over. We handed over Waterkloof Airport, we handed over Lanseria, we handed over a portion of the OR Tambo to the AU summit, to say this is not under our control during the ICC during the conduct of the AU summit in South Africa. So that is just another. But 4 days or so before the actual hosting, because we are members of the ICC, we sent very senior officials to the Netherlands who were not even given the courtesy to have a meeting with a prosecutor, which is expected to say, we have no intention of undermining our own institution or organization. Here are our people. So they went and came back home without being given a hearing. So that is just another matter. But what I want you to note is that when you intend to withdraw, the Minister of International Relations and Cooperation need to say so to the international community through the UNSG's office. The ratification process then comes back home. And our intention is to couple the de-ratification with statutes that will make sure that South Africa remains where we are. But the number one safeguard we have is our constitution. Number two, we have a very strong and independent Chapter 9 institutions. So there are no intentions of ever condoning impunity in this country, or ever looking the other way on issues human rights. Secondly, at the AU, we are at the forefront of strengthening of institutions of the African courts in Arusha. But thirdly, recently we just had a case of Africans trialing another African, the former president of Chad, in Senegal. He was found guilty and he's appealing. So impunity, no, 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 no. And we have all these safeguards. 2, human rights, that's our second name.
That was our reporter there, Aldrin Sampier, speaking to International Relations Minister Maite Nkoana-Mashabane on a wide range of issues, including South Africa's decision to leave the ICC.